Case summary. Case citation. Watford Electronics Ltd v Sanderson CFL Ltd 2001 WCA Civ 317 Court of Appeal of England and Wales Judges Lord Justice Chadwick, Lord Justice Aldous and Lord Justice Robert Walker. Background facts. Claimant plaintiff Watford Electronics Limited. Defendant Sanderson CFL Ltd. Watford Electronics Limited entered into a contract with Sanderson CFL Ltd. for the supply and installation of a software system designed to manage Watford's accounting, sales and purchasing functions. The software system was part of an integrated solution to enhance Watford's business operations. However, after the installation, Watford Electronics claimed that the software system was defective and did not perform as promised, leading to significant business losses. Watford Electronics sought damages for breach of contract and misrepresentation. Argument. Claimant's argument. Watford Electronics argued that Sanderson CFL Ltd breached the contract by supplying a defective software system that failed to perform as promised. Watford also claimed that Sanderson made false representations about the capabilities and suitability of the software, which induced them to enter into the contract. Watford sought damages for the losses suffered due to the alleged breach and misrepresentations. Defendant's argument. Sanderson CFL Ltd contended that they had delivered the software system in accordance with the contract terms. They argued that any issues with the software were due to Watford's own operational practices and not defects in the software itself. Sanderson also relied on exclusion and limitation clauses in the contract that purportedly limited their liability for such claims. Final outcome. Judgment. The Court of Appeal ruled in favor of Sanderson CFL Ltd. Legal justification. Exclusion and limitation clauses. The court examined the exclusion and limitation clauses within the contract. These clauses were designed to limit Sanderson's liability for any failures or defects in the software. The court held that these clauses were valid and enforceable, provided they met the test of reasonableness under the Unfair Contract Terms Act 1977 UCTA reasonableness test. This test considers factors such as the relative bargaining power of the parties, the availability of alternatives, and the overall fairness of the terms at the time of contracting. The court found that the clauses in question were reasonable. Watford Electronics, being a commercial entity, had the opportunity to negotiate the contract terms and was aware of the limitations of liability imposed by Sanderson. Misrepresentation. Regarding the claim of misrepresentation, the court held that Watford Electronics failed to prove that Sanderson made any false representations about the software. The court noted that the representations made by Sanderson were mere opinions or statements of intent, which did not amount to actionable misrepresentations. Key concept implications. This case underscores the importance of exclusion and limitation clauses in commercial contracts, highlighting their potential enforceability if they meet the reasonableness test under UCTA. It illustrates that commercial parties are generally expected to take responsibility for the terms they agree to, especially when they have the opportunity to negotiate those terms. Key learnings. Candidates should understand the significance of exclusion and limitation clauses in mitigating liability in commercial contracts. It is crucial to draft clear and reasonable clauses that can withstand judicial scrutiny under the reasonableness test. Misrepresentations must be clearly distinguished from opinions or statements of intent to form the basis for legal action.